Hi folks, and welcome back to Contract Law. This is video 3 in the video series on the V3, the 3 vitiating factors of duress, undue influence and unconscionable conduct. And in video 1 we did a bit of an overview of the common threads among the 3 different vitiating factors. In video 2 we had a look at duress, and now we look at undue influence. So without further ado, let's hop into undue influence. Now, as I said in the overview video, undue influence is a creature of equity, and it has a lot of similarities with duress at common law because it grew out of equity's desire to provide remedies where the pressure that was being exerted, or the influence that was being exerted by the dominant party, didn't amount to something as extreme as, a death threat or some kind of threat to your goods, direct threat to your goods or your economic well-being. And the pressure constituted perhaps something a little bit more subtle. And what the courts tend to use as their measuring stick for undue influence is that one person has a position of ascendancy or influence, either because of some kind of actual influence that they can exert given the circumstances, or because of the relationship that they have with the other party. Now, you can see where the ascendancy or the influence arises because of some circumstance that they can manipulate to their advantage. You're getting very, very close to the common law vitiating factor of duress, aren't you? And that's where the similarity arises with category 1, actual undue influence. The undue influence that arises in relation to a relationship might arise in a couple of different ways. There are some special relationships that the courts have recognised that give rise to an automatic presumption of undue influence because of the really tender nature of the relationship. Or there are the other category 2B relationships where they're not recognised strictly by the courts as being typical of the special nature of relationship that would automatically give rise to a presumption of undue influence. Nevertheless, one of the parties can prove to the court's satisfaction that they should be treated that way. So that's the category 2 relationships. We'll talk about both category 1 and 2 and the presumption and remedies. Okay, so jumping into category 1. So here the focus is not on a relationship, but the court is really looking at the factual matrix for red flags that might show a circumstance of actual influence being exerted or a situation of general domination by one party over the other party. And if you can step through these elements, then you will hopefully have some success. You need to show that one party has capacity to influence, the influence was exerted, the influence was undue, and the influence caused the entry into the contract. If all of those things are present in the factual matrix, then you might find equity will intervene and declare the contract voidable. Interestingly, having led you all up the garden path to convince you that the actual undue influence vitiating factor is very similar to duress, they were argued in tandem in the Barton and Armstrong case that we looked at in video 2. So in that case, the Privy Council held that the plaintiff could avoid the buyout deed. It was voidable, either because the threat amounted to duress or because the threat amounted to actual undue influence. Another interesting case of actual undue influence is Williams and Bailey. That was a son and father being coerced in relation to a financial transaction by a bank. So Barton and Armstrong, good example of these vitiating factors coalescing, as I said, hopefully after today's videos and particularly after the unconscionable conduct videos, you'll start to make links between not just these vitiating factors, but also the other vitiating factors that we've had a look at in previous video series. So that is actual undue influence. In relation to general domination, circumstances that show some kind of domination, general domination going on between the parties, we have Khan and Khan. This case is useful for a number of different considerations that you need to think about when you're going to make an argument of undue influence, and I'll wrap it all up at the end and hopefully draw out some salient points for you. But the facts were as follows. A son and mother that owned a house were in negotiations with a husband and wife to sell the house to them. They allowed the husband and wife to take early possession of the home in return for payment of rent. Things were fairly friendly between the parties. However, there started a process of some bickering about how much money should be paid over in terms of the rent, and the husband and wife said, "Oh, there's all this further work that has to be done to the house that we weren't aware of," and then there was a fatal dispute that kind of triggered all of these circumstances, the things going pear-shaped. So a dispute over rates, basically, and the husband and wife were starting to get a little bit pernickety about the amounts of money that they were paying over to Mrs. Sadiq. Mrs. Sadiq, at this point, then being a reasonably astute businesswoman, then gets fairly annoyed at all of this bickering and says that she really doesn't want to sell a house to the husband and wife any longer. Now, all of the parties to this unfortunate set of events were Muslims, and at this point, the son, Mrs. Sadiq's son, really thought that himself and his mother were honour bound to complete the arrangement with the husband and wife to actually sell the whole home to them. And so what happened was that he arranged a meeting with himself and his mother, the husband and wife, and also the local mufti, the local Muslim religious leader. And the mufti was really there not to exert any influence, but simply to provide what he saw as appropriate spiritual guidance in the difficult relational aspects that were going on between the parties. You can probably see that the situation is ripe for an atmosphere of undue influence, general domination by the mufti over Mrs. Sadiq, who was now unwilling to sell. Interestingly, and this is why I said it throws up some issues that are useful to take away for budding young lawyers. You need to think through how you're going to make your arguments, because the situation here of spiritual influence is the classic kind of influence that can slip into a category 2A scenario of undue influence, in which case then you have the benefit of the automatic presumption that there was undue influence, so you don't have to hop over all of the elements. Nevertheless, this was argued as a case of actual undue influence, that domination by the mufti. So unfortunately for Mrs. Sadiq's legal team, they had made more work for themselves in the way that they argued this. Ultimately, they were successful, but as I said, word to the wise, think through how you're going to make your arguments. So what happened in terms of the facts once the meeting occurred was that the mufti said all were required to complete this particular contract. The agreed amount had been $490,000. He emphasised the Muslim belief that your word is your bond, and that you must honour what you say you'll do. Mrs. Sadiq took this as a religious instruction to her but she still, being the astute businesswoman that she wasn't necessarily comfortable with just rolling over and selling at the $490,000. She really didn't want to sell, despite the fact that the Mufti was encouraging her to do so. The Mufti even said, the deal is done. Mrs. Sadiq kind of, what shall I do about this? How can I comply with the Mufti's instructions but still back out of this deal? So what she did was she actually upped the price and said, look, okay, I will honour this deal if the other parties can come up to $510,000, because she thought that was a price that the husband and wife just couldn't afford. So really she was, killing two birds with the one stone, kind of, so to speak. Unfortunate analogy there, but she thought that she'd be able to comply with the Mufti's instructions, but also be able to back out anyway. There then ensued some further negotiations at this meeting, and then the husband and wife said, well, we can come up to $495. At that point, the Mufti said, you have to take $495 because that's all that the husband and wife can afford. And then you see some kind of otherworldly inducements being thrown Mrs. Sadiq's way, kind of like the carrot before the stick. So the Mufti said, well, you'll be rewarded in the afterlife if you go through with this deal. And this was, what a good adherent of the religion would do. And then you have the stick afterwards saying to her, lucky you're not in any other country. If you had been in a Muslim country, it would be a different story. Now, at that point, Mrs. Sadiq's evidence suggests that she knew that the Muslim leader, the Mufti, was closer to God, and she was worried about incurring the spiritual wrath, so to speak. The inference was that certainly if she was in a Muslim country and she didn't perform an oral agreement, she would be in trouble. So at that point, once you had the Mufti kind of carrot and stick, and then you also had both of her sons and the Mufti saying, look, this is all they can afford, you really have to sign. What happened then? Well, obviously she signed. So the question here was whether this could be a situation of actual undue influence here with the domination of the Mufti. So the Mufti, as you can see, is a third party. And can you then sheet home that influence that caused Mrs. Sadiq to sign on the dotted line here? Can you sheet home that influence to the husband and wife? They tried to argue that there was no undue influence here. Indeed, she was, as I said, an astute businesswoman. She didn't cave immediately. She knew that she wasn't legally obliged to sell. She owned a number of different residential properties. So they're setting up the case of her doing this of her own free will. Nevertheless, the court held that none of that really outweighed the fact that this was a clear case of actual undue influence. How did we sheet home the Mufti's influence to the husband and wife? Well, what happened was that the husband and wife, obviously they approved what the Mufti was saying, but they did a couple of things that clearly indicated to the court that they knew that she was being kind of backed into a spiritual corner, so to speak, and they wanted to take the benefit and they didn't want her to have second thoughts. So what happened was that the husband got Mrs. Sadiq not only to sign a standard conveyancing contract on the spot, but he knew that that conveyancing contract would have to go to lawyers and be approved and all of that kind of thing, and it might give her an opportunity to back out. So what he did was he got Mrs. Sadiq to also sign a memorandum on the spot, which he could waive and say, this was agreed between the parties on this date, an extra layer of insurance to make sure that she didn't actually back out here. So the husband and wife were present when the Mufti gave all of this spiritual advice, and in fact the Mufti signed as witness to the parties' signatures on the contract. So given all of that circumstance, it was very clear that the husband and wife could not show that they did not take advantage of her obedience to the Mufti. And there was a case of actual undue influence. And you had Sadiq, as you can see over on the left-hand side there, Sadiq is Y. Sadiq, under the influence of the Mufti X, disposes to Z, being the husband and wife. So good little example of not only actual undue influence, but working out how you're going to argue your undue influence and whether you might, whether your factual scenario might get the benefit of one of the category 2 types of relationship and that automatic presumption. And it's also a good example of third-party undue influence. Now, in none of this was it suggested anywhere that the Mufti did anything untoward or improper. It was simply a case of spiritual advisor, devotee, and the natural influence that flows from that kind of scenario. But what was improper was the husband and wife taking advantage of that and seeking to keep the advantage. So that is Khan and Khan. As I say, interesting on a number of different levels, really. So that's actual undue influence. And now we need to look at relationship-based undue influence. And the first category is category 2A, and these are the special relationships. As I say, these will throw up an automatic presumption that there has been a situation of undue influence, and it is then for the beneficiary of whatever is being, whatever contractual advantage is trying to be retained by the recipient. It's going to be up to them to actually disprove the undue influence. So the recognised categories here, none of this is real rocket science, and these categories aren't closed, but they certainly are very well defined. So you have parent and child, doctor and patient, guardian and ward, fiduciaries. So anyone that equity would see is in a position of trust and confidence, like a trustee, the person that's looking after the legal affairs, or a Sadiq trust, the person that's the beneficiary of a trust. They are in a fiduciary relationship. There is a situation of stronger and weaker party, more advised, less advised, classic fiduciary kind of scenario there. That's going to be a recognised category. Solicitor and client, physician and patient, religious influence. This is where Mrs. Sadiq's legal team should have tried to slot their arguments. Interestingly, not husband and wife and not fiance and fiancée. So they're your special relationships that will give rise to the benefit of the presumption of undue influence. Then we have category 2B, and these are the other relationships where you do actually need to prove that one party had the situation of ascendancy or influence, trust, they've reposed their trust in the other party, trust and confidence, and dependence. So they don't get that automatic presumption. But once they do prove that there is a relationship of ascendancy and influence, dominance and trust and confidence, once you do prove that to the court's satisfaction, then you will be treated effectively like the other category 2A relationships. And here we have the case of Johnson and Buttress. Now, Johnson and Buttress were not standing in an antecedent relationship that fell within the specially recognised categories of relationships of undue influence. However, that relationship evolved over time. So Mr. Buttress was 67 years old. He was wholly illiterate. He was found by the court to be of low intelligence. He had little experience or capacity for business affairs. Unfortunately, his wife died, and so what happened was he developed this relationship of trust and confidence with one of her blood relatives, relied on her for most things, and after some years decided to transfer the land on which his house stood, because she'd been so kind to him, particularly after his wife had died. And at this point you're thinking, well, that sounds fair enough, possibly. Couple of flags though. After he suggested that he would make this gift, she took him to her solicitor to have the transfer done, and she didn't suggest to him at any point to get his own independent advice. So they were certainly factors that weighed on the court's mind. After Mr. Buttress had died, his estate tried to have the transfer set aside, and it was held that the Category 2A relationships are certainly not exhaustive, as I said before. So wherever the relationship is between donor and donee, something that consists of dominion and subservience, dominion over the former by reason of trust and confidence reposed in the latter, the presumption of undue influence is raised. If so, then it's incumbent on the person that's going to receive the benefit of the transaction that it was the pure, voluntary, well understood act of the mind of the weaker party, the donor. Now, here we had dear old Mr. Buttress being, as I said, illiterate, ignorant of affairs, particularly business of affairs, had kind of some quirky characteristics, personality characteristics in his disposition and manner that all added up to a person clearly in a weaker position compared to Mrs. Johnson. For Justice Stark, particularly his age and capacity, the fact that it was quite an improvident or unfair transaction. He was basically giving everything away. He'd had no other advice, and some other circumstances in the wings there. It all added up to a relationship of trust and confidence. She should have done more to ensure that his interests were best looked after. It's when you do equity, you'll find out that one of the responsibilities of a fiduciary that's in the stronger position is to act in the weaker party's interests and no one else's. That is, they really must be very focused on protecting that weak party. That's not really what happened here. So because of this relationship of influence, she had to show the gift was the free exercise of his will. The court makes the point that particularly where you have a weaker party like Mr. Buttress that is of low intelligence and illiterate, quite ignorant of any business affairs, you have to go an extra mile basically to be able to show that their actions were indeed the pure, voluntary, well understood act of the mind, as you can imagine. So because of all of that, the presumption was raised. She failed to rebut it and the transaction was set aside. So that's Johnson and Buttress. Makes eminent sense, really, doesn't it? In terms of rebutting the presumption, just to give a little exclamation point to the end of Johnson and Buttress, how best can you actually go ahead and rebut the presumption? Firstly, and this is the gold star standard, getting the other party to get their own independent, competent legal advice. In the case there is Inchi Noria. If you can show that independent advice would have just been ignored, that might weigh in your favour. Sing and sing is the case there. If you can prove the donor's ability to form an independent judgment and that they're the kind of character that just would have gone ahead and done things their way anyway, that might also weigh in your favour. Reed Brocklehurst's estate is the case there. So they are the ways that you might rebut the presumption. independent legal advice, that's the way to go. Remedies, we don't need to say a whole lot, do we? Because the contract will be voidable, you need to get in quick with your rescission, otherwise you might face some of the bars to rescission. Latches is the big one here. They can give rise to an inference that you've actually gone ahead and affirmed the arrangement. All Card and Skinner is the case there. Another religious influence case. Lady gave pretty much her major assets over to a religious order and then left the order 6 years later, sought to recover what she'd given over. Unfortunately, was too late. So you might also seek ancillary orders, restitutio, getting back what you've given across. So there your remedies in terms of undue influence. And that is undue influence. That's the end of video 3, guys, and I'll see you for the concluding video, video 4. Bye for now.